My name is Troupis, and I am an attorney, been practicing 37 years with a specialty in constitutional law. And I've been involved in a number of election law cases, established some important precedents in the area of election law, ballot access, constitutional issues. I was contacted by a group of interested citizens who wondered whether anyone without a political agenda had actually looked at the initiative that was being proposed for Count My Vote. And they asked me to take a look. I did, and I did an analysis of the constitutionality of the Count My Vote initiative for them. The Count My Vote proposal had this claim that is repeated throughout, that it was almost beyond question that a state could force a party to have a primary election as its selection of its candidates. Well, the Supreme Court, even though you can find that quote in several cases, in each of those cases, the Supreme Court ruled just the opposite. In the Democratic Party versus Jones case, one of the principal ones that they cited, California tried to force the Democratic Party to have a blanket primary. And what a blanket primary is everybody's name appears on the ballot, whatever their party affiliation. And voters can pick and choose among the various candidates. So they could vote for a Democratic candidate for president and a Republican candidate for governor and back and forth. That's a blanket primary. Whereas they had a closed primary. The court held the Democratic Party could retain its closed primary, and the state's attempt to force them to have a blanket primary was simply unconstitutional. Similarly, in other cases, every one that quote is cited, the Supreme Court has said the party cannot interfere with, or the state cannot interfere with a party's selection process in how it decides to select its candidates. A second aspect of that is that the Count My Vote initiative also obliterated the internal affairs of the party. It eliminated the caucus convention system entirely, even as an option. Well, the Supreme Court has held repeatedly that a state cannot substitute its judgment for that of a party in the handling of its internal affairs, especially in the selection of its candidates. Every time a state has attempted to do that, the court has struck it down as unconstitutional. So on two strikes, Count My Vote would likely be held to be unconstitutional because it eliminates the caucus convention system, obliterates choice there on the part of the party, and it forces a mandatory primary. There's plenty of precedent holding that both of those would be unconstitutional. The First Amendment was written the way it was. The free speech portion of the First Amendment is to protect political expression. In fact, our Supreme Court has said that the free political expression, political association, is the most fundamental of civil rights, of constitutional rights. And that because without that, you have no other rights. And so, the Supreme Court has said that in the selection of its candidates, the party is exercising that most fundamental principle of political speech, that critical phase at which they select who's going to be the standard bearer, who's going to carry the party's message. But it's not just the party, because as you remember, the party is a gathering, a group of individuals, of people. The founders felt that without strong political parties and the ability of people to collect in the form of strong political parties, that our republic would not survive. So it is the most cherished, fundamental constitutional right. And as a result, it is given the strongest protection that the Supreme Court can give it. It is absolutely protected to the greatest extent that the Supreme Court protects any rights. That really isn't how constitutional law works, and for good reason. If the majority rule made everything constitutional, back in the 30s, 40s, 50s, and even 60s, we would have had segregated schools. We still would, because at that time, a majority of Americans, and a majority in many states, decided that segregated schools were what they wanted. You simply cannot have a majority decide what is constitutional, or else it would become the tyranny of the majority. In fact, we have a written constitution for the protection of minorities, for the protection of every citizen, so that whether or not you are popular or unpopular, your rights are fundamentally protected. Constitution is that document that provides a rule of law. So even if a majority passes something, it still must pass constitutional muster. It still has to protect basic fundamental rights that are so important to the preservation of our republic. So no, even though a majority of the citizens of Utah might vote for an initiative for whatever reason, doesn't mean that it is sufficiently protective of the constitutional rights of everyone in Utah, and therefore it has to pass that constitutional test as well. So Senate Bill 54 keeps the provisions of the initiative, Count My Vote initiative, which is the mandatory primary. But that's only one option, so that's on the left side of the table. On the right side of the table, the party has a second option. Political parties may choose to keep their caucus convention system, but as I like to say it, they can keep them, but they've been neutered. Because as a part of that option, if they elect to be a qualified political party and have caucus convention, they must also allow for any candidate to collect signatures and get on the ballot that way, even if that candidate's been rejected through the caucus convention system. And finally, they must engage in a primary election for all of their nominees, and that primary must be open to all voters. So you have A or B. The mandatory primary of the initiative, which can be either open or closed, or the option B, the caucus convention system, but also an alternate route to the ballot if you collect signatures, and an open primary. Senate Bill 54 simply doesn't do enough to make constitutional what was unconstitutional in the initiative. And it adds other components that make it even more subject to serious constitutional question. So in order to explain, let me give you some fundamental precepts of constitutional law. As I've said, the First Amendment protects the fundamental right of political parties to have freedom in the selection of their candidates through a process that the party wants to use, because that group of people have the right of free political association. As we said, the initiative violates that precept. There's at least 4 seminal constitutional cases decided by the Supreme Court that establish this right, starting with the Republican Party versus the state of Connecticut, Tastion versus the state of Connecticut Republican Party. In that case, the Republican Party wanted an open primary, and the state wanted to close the primary. The Supreme Court said, no, you can't tell the party what kind of primary to have. The second case, Democratic Party versus Jones. The Democratic Party had a closed primary. The state said, no, we want to make it a blanket primary. The Supreme Court said, no, you cannot tell a political party what kind of primary to have. In the third case, New York Board of Elections versus Lopez Torres, the candidates for judicial office wanted the party to select them in a primary rather than a convention. The Supreme Court said, no, the party has a right to have a convention system, and for the selection of its candidates, the state may not interfere and force them to have a primary. And finally, in the Washington Grange case, the Supreme Court said that the state of Washington could enact a non-party primary for the 2 top vote getters, but only because the Supreme Court said it doesn't interfere with the party's independent means of choosing its own candidates through another selection process. Now, why are those 4 cases important? Because in all 4 of those cases, you find the same quote that was used by the initiative proponents as the premise for their claim that a state could force a party to have a primary. You hear Justice Scalia's statement in four cases, that same quote, but in each case the Supreme Court decided no, the party's rights are paramount. And that's because the First Amendment rights are paramount. All of that is incorporated into Senate Bill 54. I mean, the same problems that the Supreme Court's already struck down, with the additional component that now Senate Bill 54 has the option to preserve the caucus, but only in a neutered form, which is you have to allow an alternate route to the ballot through signature gathering. That too is unconstitutional, likely unconstitutional, because of a case, Supreme Court case law in a case called 44 Liquor Mart. And in that case, the court said that even though government may not be required to provide a benefit to the public or a person, they cannot condition conferring that benefit upon the surrender of a constitutional right. And in that case, the government tried to limit liquor licenses, condition them on the companies agreeing not to have certain kinds of advertising, a First Amendment right of free speech. The court said, no, you cannot take away free speech rights, which is First Amendment political rights as well in the highest form. If you're going to, in order to condition, you can't condition the grant of a license on those rights, even though you didn't have any obligation to provide licenses. By the same token, Senate Bill 54 says you can choose to be a qualified political party. But by doing so, you have to give up your right to a closed primary. You have to give up your right to an exclusive caucus convention system. You have to agree to these conditions. That's an unconstitutional choice. And that is probably the most well-defined and clear example of constitutional principles that the Supreme Court has ever laid down. So, in my opinion, Senate Bill 54 is even more likely to be held unconstitutional than the initiative, which only had half of it. The severability clause is generally included in a statute so that you can separate out, excise any portion that is questionable or unconstitutional, and then leave the rest in place. So if this law had one small part that was unconstitutional, that part could be struck and the rest of the bill would stand. But in this case, that's not easy to do. In fact, I think it's almost impossible to do. Because if you choose column A, which is the mandatory primary under the initiative model, that's unconstitutional. But if you go on the other hand and you choose column B, which is the qualified political party route, that is also unconstitutional. So you really don't have a safe choice. Even if you strike out column A or you strike out column B, the alternative is just as unconstitutional. And even if you pick and choose pieces between the two, it is so intermeshed and intermingled that it would be virtually impossible to separate the constitutional from the unconstitutional without utterly destroying this statute. So I just don't think it's possible to save it on those grounds. It's simply wishful thinking. You know, I think that they absolutely should. Of course, it's not my decision, but I think they should for these reasons. First, I think that in order to vindicate their fundamental constitutional rights against an assault by the state in this case, I think it's terribly important, critically important that the party assert those constitutional rights and establish the precedent that no state can run roughshod over them. But even more important, or as important, I think that the party has to stand for the rights of its members and the people at large to participate meaningfully in the election process. Count my vote was really count my vote worthless, because without party involvement, without party organization, without that caucus convention system, the people's votes were scattered and wouldn't have any meaning. This is no better. And I think if the parties believe in the reasons for the caucus convention system, they must fight to preserve it for the sake of all Utahns. I think that it's critically important. So I'd highly recommend that the parties get together and sue to establish the unconstitutionality of this statute. And then they should work to make the caucus system as responsive, as inclusive, as available to all Utahns as possible. Because a healthy caucus convention system is the best answer for the citizens of Utah.